Right, welcome, folks. As Tom said in the other room, I'm Tim O'Brien. He made a comment in there, and I want to clarify it, though, because he said if you find yourself on the wrong side of the law, you should give me a call. I want to make clear, you can be on the wrong side of the law and still be legal. It's, those aren't just necessarily, or guilty. I mean, you can be innocent and be on the wrong side of the law. So we do try to help people when they get themselves in jams that would bring them into court. That's where I spend a good amount of my time. I'm here to talk about implements of husbandry. I made a joke to a couple of folks as they were walking in that I expected maybe 2 or 3 people in this, but obviously this has been a very big topic over the last 3 to 5 years especially, and now there's been some legislation, so we're going to talk about that. How did I come to implements of husbandry, to know this stuff? Well, I'm a city kid, although from Chippewa Falls, so I knew some farmers when I was growing up. But about 15 or 20 years ago, Tom Schumacher had a client. And the client was a local farmer and one of the first bigger farmers in the area. And he had fields. Some of them were near the farm. Some of them were a couple miles from the farm. Some of them were 7 or 8 miles down the road. And so what he would be doing is, he would start at one field and then move down to the next one. Well, to do that, he had to go on a town road. And it was about 7 miles from one place to the other. Well, there was a local state patrol officer who had what he believed the law and his view of it was. And he waited because he knew that these guys took this trip pretty much every day in the spring and then again in the fall. And he wrote him a citation for not being registered. And what he was pulling was he had a tractor and he was pulling a wagon of some sort. I don't even remember all the facts of what exactly it was, but clearly it was a farm implement or a farm vehicle that he was pulling, or that he was driving and pulling. So Tom sent him in to talk to me. Well, I sat down with the client and I met him and I said, well, tell me about what was going on. I said, were you driving a vehicle? He says, yes, I was. I said, were you on a road? He says, yes, I was. And I said, was the vehicle registered? He says, no, it wasn't. And I said, and you're going to pay me for this $200 ticket. I think you might be better off just paying the ticket. And he said, you don't understand. It was an implement of husbandry. And he was right, I didn't understand. Implement of husbandry, if you would have asked me, I would have said, well, that's what my wife probably calls me to my friend, to her friends, yeah, the implement of husbandry, he didn't clean up the garage again this week. But anyway, so one of the great things about being a lawyer is you can learn lots and lots about one little thing. And that's what I did about implements of husbandry. As Tom said, I'm a trial lawyer. I really like being in a courtroom. And of course, I have always dreamed I'm going to be the guy up there if somebody's wrongfully accused of murder and we're going to get them off and fighting. And well, here I was fighting a traffic ticket, And it did turn into almost like World War III, though. We had to write briefs to Judge Needham and we go to this long, involved process. And as I was learning about implements of husbandry and the law regarding it, what did I find out? Well, the law was about as clear as manure, I mean, it was hard to read through. Now, this was a registration case. And so what you needed to do is, for an implement of husbandry, and many of you probably know this, but there's 3 things it had to be. You have to have a vehicle designated for agricultural purposes, that's number 1. Used exclusively in the conduct of agricultural operations, and 3, used principally off the highway. That's what the law said. That was the statute. Well, we certainly had number 1. It was a tractor and the trailer or the wagon that was being pulled. It was used for ag operations. It was taken from field to field and was used in the fields. The question was it used principally off the highway? Well, I looked at that and said, of course it was. Most of the time is spent going up and down the fields with this. Well, what does the word principally really mean? And so does it mean primary purpose? Is the analysis, what's the primary purpose of this thing? Because if it's the primary purpose, we win easily. because the primary purpose is to use it in the farm operation. But our Court of Appeals, in their infinite wisdom, had described it as de minimis highway use. Okay, now what's de minimis highway use? Is that 5%, 10%, 20%? Does it matter if all of your farm fields are really close to each other? If you happen to rent from your cousin who's 5 miles away, should you be treated differently than the guy who rents from his cousin who's a mile away? So all of these things start to play into it. And as I said, we had 7 or 8 miles to drive. Well, Judge Needham, in his infinite wisdom, did find that that was, no matter how he defined it, it was, the issue was it was used principally off the highway. He said it was. It was just, hey, you got to get to your field somehow. I don't think the legislature meant it to be that you couldn't drive to get to your fields. So we win. Well, nobody appealed it. It was St. Croix County. The DA's office said, yep, you win, we're done. Fast forward to 2012. I have another farmer and another vehicle. And I'm going to describe the vehicle because it shows you a lot about what we're talking about. Because what we're really talking about is how much farming has changed over the last 15 or 20 years, especially the vehicles. So it was a manure spreader. But what it really looked like, if you looked at it, was a commercial dump truck. And what it had was it was equipped with a moving floor system. And it pushes the manure to the back, and then it's expelled on a spreader. So basically, you have a spreader on the back, you've got a moving floor, but on the outside, to do all that, you had to have the switch to turn on the moving floor and such. Well, that switch made it so we were about 6 inches too wide for driving on the road. And then, of course, because you're going to use this huge truck in the fields, you needed bigger tires, okay? So the tires were about 2 to 4 inches wide now when we did this. So that was what we're now dealing with the second farmer. And this was just, as I say, in 2012. The interesting thing about this vehicle, which was determined eventually, and we'll get to it, was determined to be too big, too wide, is that it was manufactured specifically for this purpose by a Wisconsin manufacturer. And nobody had said a thing when they're selling them, when they're manufacturing them, when they're using them. So what happened? Well, there was a state trooper in Buffalo County who also happened to be a farmer, may have been in competition with our farmer for certain things, and didn't really like our farmer, which he wasn't the most likable guy at times. I have to give him that one. But he cited him. And so he cited him. What had happened is there was an accident. And of course, when there's an accident, the state patrol comes out and they start checking things out. Well, he cited him for being over width and overweight. And there really wasn't an issue about the overweight. He knew it. It was one of those things. But so what's going on now? Well, I'm the resident expert on implements of husbandry. I take the case. But what had happened in the intervening years from that first case to this case? Well, as I said, we all of a sudden have these vehicles that had never been used before. They're huge, and it's like now you're out in Montana or something where they have those outrageously big, but they're using them here. You have the changes to commercial motor vehicle licenses and CDL operators where they all had to have specific licenses. And you couldn't have people going between states, so the states had to adopt all these rules that the federal government put in on CDLs. So you had that going on. You had larger farms, so a lot more farms where you might not have fields that are close to each other. I mean, you might have fields all over multi-counties. And so you had that going. And then they had changed the statutory definition in the intervening years, which of course I didn't know till I went and looked at the statute. Oh, that's new. And they had kept the registration where you didn't have to register, but now they had two new definitions, and actually 3. They had a farm truck, and then they had a motor truck, and then a commercial motor vehicle. And the state's argument here, the DA just basically argued, this is not an implement of husbandry. No matter how you do it, it's not an implement of husbandry because It's a commercial motor vehicle. It's over, I think it's 35,000 pounds, or 28,000 pounds, I believe it is. So anyway, it's a commercial motor vehicle. We don't even have to talk about all this implements of husbandry stuff. Well, I couldn't believe that. So what do? I'm getting smarter because I'm getting older. I call the Department of Transportation. I said, I want to talk to whoever's in charge of this section where you define what Section 340 means. I get somebody on the phone, nicest woman you could talk to. She wouldn't answer my question. She just refused. She says, yeah, that's a real issue. We know that, and we're talking about what we should do about that. I said, well, what do you mean? She said, we'll get back to you. Okay. So my client, he says, well, we got, this is going to affect all the farmers in the state. We have some, we can get our groups behind us. I think it's WPPA or WFP, the place out of Green Bay, WPPA. They'll back us all the way on this. I said, well, okay, that sounds good. Let's get them. So I call over to the WPPA and I speak, and again, just the most helpful, friendly person who says, well, from what we find, they're only really enforcing this in 2 places in the state, Buffalo and Pepin County, where your client lives, and over by Wausau in Marathon County. So we'd really prefer that nobody makes any waves, because the other 69 counties, farmers are loving it, kind of thing. So, okay, so that's what we're dealing with. So they don't want to rock the boat, but we do start getting meetings set up with the Ag Department and with WPPA and some of the other folks there. But basically, nobody wants to really answer the question, what is even an implement of husbandry? Well, as I started going through this process, what I found out, because I sat in some of the meetings, is there's obviously competing interests here. The towns, some of whom are farmers, but some of whom aren't, are saying, well, what about our roads and bridges? The wide ones we don't really care about so long as they have lights on them and they're safe and that sort of thing. But the weight is a real problem for us. I mean, you can ruin our roads pretty quickly, and bridges are going to fall. And that was really, in the DOT, what I didn't understand at first is there's some factions in there too. The road builders, of course, are saying, well, you got to be able to use the roads. But the safety side of it, the state patrol and the enforcement side is saying, well, wait a minute, you're ruining our roads. And so there is some tension there. So we have our court case. Well, Judge Duval, who is one of the best circuit court judges in this part of the state, took a look at it, and he said, well, I'm not going to dismiss the citation because I do find, there's no question, this is designed for agricultural purposes. Even if you could take or shut the motor off and use it to carry stuff like a dump truck, it was designed. We can see the design behind it. It's being used for ag purposes. And here's the thing about this truck. It could take basically what you would put on 40 wagon loads of manure. You could put it in one, take it out there, and spread it literally in minutes, as quickly as you can drive up and down the field. Well, that's going to come back to bite us in a minute, because the issue was whether it was used principally off the highway. And we had to go to trial on that. That was the factual issue. And our argument, in a sense, was, Judge, the distance between the home farm and the field can't define what we do here. You can't use this de minimis. You got to use, how's it principally used? How are we using this implement to do it? And the judge said, no, there's a case here that the potato farmers actually won, and it uses the term de minimis. And he says, one of your problems here, I got to follow the law, but one of your problems here is this thing is so efficient that you get down the road, it takes longer to get from the home farm to the field than it does to do the damn spreading, And so he said, it's not de minimis. It's 20 to 30% of the time is spent on the roadway, and that's being generous to your client, and therefore we're not going to find that it's an implement of husbandry. Well, what does any good lawyer do when you lose? Appeal. Yeah. And we did. And the state, the district attorney, when it went up, they renewed the argument that this wasn't even an implement of husbandry at all. judge had gotten it wrong at the trial level. This was really the definition of a farm truck and a commercial motor vehicle, and so you don't have to get to this. And they're basically saying the commercial motor vehicle can never be an implement of husbandry. And so what the Court of Appeals then did is rule against us. But really what they talked again about what the definition of an implement of husbandry was, and talked about that in this definition that had been set by the legislature, because it was a motor truck, it really wasn't an implement of husbandry. But they said something in there that was really interesting. After they found all that, they said, "The result of this case is unfortunate. We suggest to the legislature that a re-examination of the relevant statutes may be in order to prevent the same result from happening in future cases." And what did the legislature do for once? They actually listened to the Court of Appeals. And of course, this was also going on at the same time the Ag Department was pushing the DOT. You had some changeover in the legislature so that the road builders, I think, got a little bit more sway. Town governments got involved, the Towns Association got involved, and everybody said, look, it's a problem and we need to deal with it. Our farm economy is the backbone of this state, and if we can't operate on the roadways, we've got a real problem. But the towns and the cities and the state are saying, but we have enforcement issues and we have safety issues, and we have to take those into consideration. So what did they do? You might have heard about it. It was the Implements of Husbandry Study Group. And I've included some of that stuff in the materials, and I'm just going to kind of you can actually follow through if you want, starting at about page 2 there, or excuse me, about I think it's page 3 or 4 of the. What they did was they decided, look, if we're going to be an ag state as we are, we have to have a sound system of roads. We have to be able to get things to market and back and forth from farm to field. But we also have to worry about the safety concerns. And so they tried to get everybody to the table, and I have a list in here of the people who were involved, because I thought it was for once they did try to get everybody from the DOT to DATCP, all kinds of ag and engineering groups, industry, private industry, the traffic operations and safety laboratory. So they had a lot of different people coming together. They identified the real problem, or the problem is that already not most, but a lot of these implements were already exceeding our limits. I mean, it was just so clear that there are so many out there. They're being manufactured in Wisconsin. I met a couple of the manufacturers, and they're like, this is our business. I mean, if they shut this down, we got problems. So the municipal authorities, as I say, you got to talk about what it means for the bridges, for the culverts, for the roads. So everybody got together, and they started talking about this. And the first thing they said is, our biggest problem is, as I said before, it's clear as manure. Nobody knows what these definitions mean. So they started by trying to create and amend the statutory definitions to assist in determining whether a vehicle is designed for ag purposes and used exclusively in the conduct of agricultural operations. So what's important? That sounds like what we just said. But what's important about that is they took out the issue of where is it being operated. It's presumed now that if it's a farm implement or a farm vehicle or even a farm commercial motor vehicle, that you're using it in an ag operation, and at some point you're going to have to drive it on a road. And this is where it becomes important to all of you. The thing everybody agreed on right away was width. We can make these wider without a significant danger. And what they did was say, but we're going to need some lighting and some other things that needed to be done. And that was, I think, pretty easy to come to. The real fight was about weight and what they could do with the weights. And so they, that's where I know a lot of the discussion, and some of you may have gone to them. They had meetings around the state. There was one in Chippewa Falls, I think. I was at that one. And they picked up information from various people. And so then they talked about a permitting system. Well, can we permit people to do it? And I have to say that I remember in the Chippewa meeting, there was a town board person there. He raised his hand and he said, I'm the biggest farmer in my township. I'm on the town board. Am I supposed to decide, whether I can make that decision for myself? I don't know that that's the right system we want here, folks. But guess what? That's in some sense what you're going to see they did. They went through all of this, and if you look, there is at the end of the portion of the outline that talks about the study group, they identified problem areas and solutions, and then they talked about how farmers and local governments can partner to solve the identified problem areas. And I think what they're really saying here is for towns and municipalities, here's your best practices going forward. And there's a list about investing in high quality subgrade where the stress is going to be the greatest. So if you have places where vehicles are slowing down and speeding up, turning in, try to make that a better subgrade or require that. Pave your shoulders and your turning points. Have longer culverts when you have driveways at the fields and pave shoulders again there if you can. And of course, I'm not here to discuss that, but there may be things, I don't know the answer to this, Tom probably does. Can you charge the landowner if we're going to go across your driveway? You're going to have to do this for us. You're going to have to be like you do with sidewalks where you just assess it. I don't know the answer to that, but something to think about. Utilize TIF districts. I'm not a big fan of TIF districts, but I understand, and use them for improvements to the roads, to the transportation. One-way traffic strategies, maybe at certain times of the year even, on certain town roads, you say it's one way going out and another way coming back. Those are things you could look at. So they did get legislation passed out of this, and I know a lot of you have seen it and have been working with it now, but it was passed just actually a year ago today. One of the things that is important to keep in mind, you still, as municipalities, have the option to protect your roads from damages. There's statutes, injury to highway statute, and the road agreements, that you can still do those things, but you have to do them correctly. And I think the one thing you'll see in the new law when you kind of parse it out, one of the things they're saying is if you're going to have permits or if you're going to try to regulate by ordinance or otherwise, you better have a reason for it. You better be able to say, this road has a bridge that is structurally not good, so we can't have heavy vehicles on it. And you still have the ability to do that. But you have to have a reason, and Tom talked about that case that came down where basically they said to the Oneidas, well, everybody's over here yelling at us, we don't want to give you your permit. Well, sometimes you just have to make a record of what you're doing and why it is. And you have engineers and you have your road folks, and they can look at some of that stuff. So that's important to do that. You can still have seasonal or special weight limits, so that hasn't changed. It doesn't cover all farm vehicles. Some of the townships and areas around here, you have logging, and so you have to consider that. Well, it doesn't cover logging. It doesn't cover sand trucks. It doesn't cover dump trucks or regular semi trucks, no matter what they're hauling. Those are still the same as they've always been. Okay, you can still regulate those. Now that might be more for the county sheriff or the state patrol, but you can still regulate. They're not covered here. The act was designed to cover farm and ag vehicles which are not normal registered commercial vehicles, but which are normally operated in fields, not on roads, but either going to be driven or towed on roads to get from farm to field or field to field. So as I said, they're trying to get away from the used principally off the highway portion of this. And so if you take that out of it, that's one thing to know. They've also now divided it out. There are implements of husbandry, and then there's ag commercial motor vehicles. Implements of husbandry is then broken down into 3 separate areas, but the implements of husbandry are what you would consider, your tractors, your trucks that you're using to pull things that are used just for your operation. The commercial motor vehicle that's a weight issue. So they wanted to kind of separate out what those are. But you can have an agricultural commercial motor vehicle now. That is a difference. Going back to my dump truck, that was over the weight limits. Because of how that was set up to be used in the spreading, that would qualify as a ag commercial motor vehicle. It was altered for ag operations is how they describe it. So implements of husbandry, I think the short version definition is it designed to be used in a field, not on the road? Okay, what's it designed for? There are changes in the maximum weight limits. They can now be 15% above the normal weight limitations. So basically it went from 80,000 pounds up to 92,000 pounds. This is important as you get into permitting and other issues, and as you're building your roads or as you're trying to protect your roads. Again, it did not increase these weight limits for non-ag commercial motor vehicles, just for ag vehicles. There are then Category B implements of husbandry. The thing about this is, while they're limited to the 92,000 pound maximum, it can't be more than 23,000 pounds per axle unless you pass an ordinance. But these are like combines, forage harvesters, self-propelled fertilizer or pesticide application type vehicles or implements. They can exceed weight limits if it's incidental in traveling between fields or between a farm and a field for less than a half mile. So in other words, those are the types of things that they don't want driving down the road all day. You have to get them to the field, but once they're there, if you're going to move them, it's got to be to another field close. Otherwise, it's got to be trailered to bring there, as I understand it. So, but they don't have to comply with Class B road postings. You probably, maybe you have, maybe you haven't, been dealing with no-fee permits. In other words, there's a permit process that's in place now that we'll get into in a second, but you can't charge a fee. So state mandate, guys, it's given to the towns and the cities and the villages and say, you have to deal with it. We'll give you the permit. It's actually on the DOT website, so it's supposed to be easy to do. Category B, again, you can require a permit, but you can't deny a permit. So in other words, if you give them a permit, but you say, but you can't go on 120th Street, well, you got to be able to let them get there some other way so they can have a different route. So you have to set up routes if you're going to say a certain road is off limits. As the bottom line is, while it permits heavier vehicles on local roads, a permit to exceed the weight limit is not a permit to damage or destroy a road. So you can still regulate. You can enact ordinances, and they can regulate, as I say, the IOHs and the CMVs. The town association has put out a nice, and I've tried to include, I did include it towards the end of the materials, 6 options basically. What can you do? Well, you can do nothing at all. Just say the state law is our law, you have to follow it. And that's where you are. Or, and one thing I want to bring out, and some of you again may know this, but the permit process and the ordinance process had to be in place by January 15th of each year for that year. they've moved that back to November 30. There's some new legislation that just came out. Tom mentioned it briefly. The new legislation says you have to, by November 30, pass the ordinance, get it to the DOT by January 20. Okay, so that's important to keep in mind because of your open meetings issues. If you're going to do it soon rather than later in any given year. You have to do it before the calendar year changes. There are, as I say, 6 separate options for the towns on what they could do. You could post road limits that limit below the new limits, but you have to, again, have a clear basis for doing so. That means engineering evidence, or perhaps that there's already been a finding that that road is not structurally able to handle the weights that are allowed here. You could opt out. That means, as I say, do nothing and have no weight limits, no limits at all on the roads. You could set an ordinance that's going to define your weight limits, and those could be more than the State Act 377 maximums, but then they would have to have a permit to exceed those maximums. You can do a partial opt-out in a different way, and that is you're only going to designate certain roads where people can be over the weight limit. Okay, so if you don't want them on a county highway, for example, or the main, whatever the main road through the township is, you can say, yes, you can be over the weight limit, but only on these roads. You can comply with all the regulations of Act 377, but you can apply to us for a permit. Or, as I said, you can do nothing and have them apply for a permit if they want to exceed the maximums. So what's all this mean? Well, these permits, they have to be no fee. There's a really short timeline for approving or denying them, 3 weeks. If you don't, it's deemed temporarily approved. If you don't take action within 6 weeks, it's approved. If you deny it, it has to be in writing. It has to have a reasonable, structurally based explanation that relates to preservation of the roadway. So again, you can't just say because I don't want you to, okay? Or under the permit option. If you're going to give permits and if you deny it, you have to have a reason for doing so. If it's the category B that we talked about, you have to approve the permit or give them an approved alternate route. We recommend that you have a person, whether it's the clerk, whether it's one board member, somebody who's designated to respond to these because there's time frames on them, and it's easier, I think, to train one person to learn these things. If you know your operators, in other words, the bigger farms who are likely to be, nothing says you can't give them a call or stop out and say, hey, just tell us what's going on. I mean, we're not here to make you trouble for you. We just want to know what you're doing, and here's what we have to do. How can we work together on it? In the materials, I enclosed the whole Act 377, but what I did was try to put little places marks where you could see what applies to the towns and what you might need to look at. It's lengthy, but as you start looking at it, it really just kind of talks about if you're going to have a permit in place, make sure you have a system. If you're going to try to regulate, have a reason for doing so. If you're going to deny people to use certain roads, you better have a scientifically based reason for doing so. Is noise a factor? I don't think noise is under this. I think you really have to be looking at weight or injury to the road or things of that nature. The last thing, as Tom said, there was just some amending legislation passed that I looked at it today. It's really long, but all it really says is if vehicles are in combination, they can still be an implement of husbandry. So if one is and the one it's towing is, they both are, that's one of the things. You look at combined weight limits, that's there. And so it was more about cleaning up some of the language and the definitions. I think I've got about 5-7 minutes left. Yeah, go ahead.
What's the difference between option B and option 7 as far as the township issuing permits?
Option B and option F.
Yeah,
B and F.
Let me make sure. The total opt-out, the difference is that under option F, you can have, under option B, you don't have Act 377 at all. They can have their as much weight as they want on your roads. Okay, now, the state patrol or the sheriff could stop them and say you're overweight. The difference, option F, is you can give them the permit to be above the weight limit.
F, you do nothing.
Right, but it,
B, you have to have an ordinance, it looks like, to get out of it, where F, you don't have an ordinance or anything.
you're right, I'm sorry, you're correct. And the do nothing does allow, both of those do allow, actually, the total opt-out, you don't have the permit, but you have an ordinance saying we're not going to follow the rules, and you don't have a permit process. F, you do nothing, you don't have an ordinance, but you can have a permit process in place to say if you wish to exceed the Act 377 weight limits, we will have a permitting process for you. I think we got that right. So, does that answer the question?
I mean, it says in Act 377 weight limits apply on option F. It's an issue, then we'd have to have a permit ordinance or something in place to do that.
Not an ordinance, but you'd have to give them the permit option that the DOT has if they want to go over those weight limits. Over,
Township would issue that.
right, the township could issue that. And the forms are supposed to be on the state, on the DOT website.
Well, it's the operator's responsibility to bring the permit to you, not you bring the permit to them.
Right, but you have to be able to respond when they come and ask for it. Yeah, exactly. So everybody heard that? I mean, it's the, if somebody gets stopped and cited, they're not going to come and say the town of Hammond's at fault. They're going to say the operator's at fault. So he or she has to get their permit, but the approval of the permit has to come through you. Yeah. Okay. So it's been interesting, these implements of husbandry. I got to see how legislation was made, sort of, and the really interesting thing is right when this got done, a friend took me over to a Packer game, and I get there, and the guy sitting right behind me was the Ag Department guy, second in command, whose name I forget right now, but he was the one who pushed a lot of this through, and it wasn't through yet. And I said, remember we met in Chippewa? He says, yeah, and he just looked at me and says, don't worry, from the farmer's perspective, we got this covered. And I'm like, and sure enough, basically everything they asked for, they got most of it. So, Michelle?
So I have a little bit of a two-part question. We still can protect our roads from damage, and we have recourse, and I'm kind of wondering what that would entail to prove that. And then secondly, what we have seen, we took option E, where we opted in and adopted an ordinance, and operators have to apply for a permit. And what we saw was we got blanket requests from the co-ops to exceed the weight limits, saying we can't tell you what roads and we can't tell you when because we can go out at any time on any road to make deliveries, and we can't predict that. And that puts us in a difficult position.
Yes. That's a good question, Michelle.
What they say is, due to the seasonal nature of our business, it is unknown until the day of application which routes of travel are to be taken. Therefore, we request permit to operate on all roads maintained under this municipality.
And what I can tell you about that is when they were talking about this is one of the very things that came up as they were trying to figure this out. Well, how are we gonna have to have a permit every day when we go out? Are we gonna have to apply every day when we go out? I don't have a really good answer for the second part of that question. I just don't know how you do deal with that. I think the first part about how do we determine, I think that if you have your own road crew, I think they could probably do it. It'd be better if you had your engineer doing it. The state does some of that. The county does some of that. What are the roads rated for and those sorts of things. I ride a bike around these areas, especially in the town of Richmond and Star Prairie. And I mean, some of the town roads, I don't think you need an engineer to go out there and say, look what they've done to the road here. So I think if you make findings, we've gone out to 120th and mile 1 is this way, mile 2 is this way, this one structure, we see these problems here, the road is cracking. I would think that would be enough. Generally, remember this too, under the law, when you as a town, as any sort of municipal actor, when you take a reasonable position, in other words, if you have two options and you choose A, turns out to be wrong, you should have chosen B, that's not a problem. It's when you do nothing and something happens. So you have discretion, and if you have a basis for it, so document it, whether it's the Plan Commission, whether it's the Roads Committee, whether it's the council itself, the board. I think that's what you have to do, is make those findings. I don't know the answer to how you deal with the second part, except to say to them, if you want to operate here, you're going to have to do it the way we tell you to, and see what happens.
The drawback, I mean, some of their answer is that, if they get a new client, I mean, they don't know today if they get a new client tomorrow, if he's on a road that they didn't apply for.
Yeah.
So that's kind of why they do the blanket thing. But
Yeah.
if they're just using your town to pass through, then it'd be nicer if we could give them a route.
Yeah, yeah.
We still restrict which roads they go on, basically dictating the routes.
Yeah, you can do that. Yes, you can dictate it. Now, the question is, can you, in effect, landlock somebody and say you can't get to that farm? I don't think you can do that,
You cannot deny access to
Yeah.
the property.
Yeah.
To prove damage to the roads, is it open record to find out their client list to know how often the road was used?
Is it an open record of the town or the village?
Because they want a blanket policy, if they notice that there is extra usage on a certain road, how do they get the information that their vehicles went on there because it's a blanket? And then if they said they didn't, but you had a blanket policy, is there any way to know that they did travel your roads? I guess that's basically.
Oh, I see what you're saying is, could you, as part of the application process, tell us how many trips you take on 120th, for example?
Right.
That's a good question. I think you could require it as part of the process. Now it's, you can't make an open records request on them. They can make one on you.
Right, but what I'm saying is if there's some way to know that they did travel a certain road, there was damage on it, it may not happen 1 year, you keep records for 2, 3 years, that you couldn't come back and say, okay, you've used it. Along with that, you might want to know the weight, the type of vehicle that was used, to know whether or not your restriction was when they want a blanket.
And I think that's a reasonable request of, for example, the operators who say, we can't tell you, we're going to be here, all the time. I know I got to wrap up here, but I think that you could make I would suggest, and Terry Dunst would probably be better on this, but I would suggest an ordinance that says we've considered these things, and here's what we believe are the factors that we must consider, and here's the evidence we need, and where can we get the evidence? From you, because you're the ones who are using our roads. And so, I'm getting the high sign. All right, hey, I thank you a lot. It's an interesting subject, and towns see it different than farmers often, but a lot of farmers are town boards, so it's good luck.